Hello and welcome to this webinar on 5 top tips on responding to allegations of intellectual property infringement. Thank you very much for joining us. I will be taking you on a tour of the general IP issues that you need to think of. This is sort of the second in a series. The last webinar that I did in November covered the 5 top tips to think about when registering intellectual property rights, and that webinar goes into quite a bit more detail on the different IP rights that are available and the ways in which you might want to rely on them. So if you're not very familiar with intellectual property, I recommend that you start off with that one and then have a listen and look at the slides for this one. Anyway, thank you very much for joining, and without further ado, I will start the presentation. So this slide may be familiar for people who watched the first one, but I think it's always good to put a face to a disembodied voice. I am Rosie Burbidge. I specialise in intellectual property law, and I help businesses right the way through their intellectual property journey. So from registration, identifying appropriate unregistered rights, litigation, strategy, and any sort of disputes that may arise in the meantime. I am also a writer. I'm afraid you will not be able to escape any webinar from me without hearing all about my book, European Fashion Law, A Practical Guide from Startup to Global Success. It comes out in February, and if you look on my website, europeanfashionlaw.com, you can find out how it can be pre-ordered. You can also follow me on Twitter, I'm on LinkedIn, and I also write regularly for the preeminent European blog, the IP Cat, which has been going since around 2002. So please do have a look at that website, and if you want to be kept up to date, then you can subscribe to get the emails sent to your inbox when they're released. So I thought it would be helpful to have a little recap about why intellectual property matters. And although this is framed more in the context of registering and protecting your rights, I think it's useful to look at it from this perspective as well when you're thinking about the motivation behind somebody writing you a letter and objecting to any form of IP infringement, which may or may not be justifiable. So intellectual property is effectively a right, an asset. It protects creativity, and this is creativity in the broadest sense of the word. So it obviously covers things like art and music and literature, but it can also cover things like software and the design of products, the way in which products are differentiated from one another. So the trademark that is added, which most obviously is a word, but it can be things like a logo or other symbol. In fact, breaking news from the UK came recently, I believe yesterday, where there is a long-running dispute between Cadbury's and Nestle regarding the registration of the colour purple in relation to chocolate. And Cadbury's unfortunately lost their appeal on that. So for the time being, at least, the colour purple is not a registered trademark. Anyway, it just goes to show that there are some slightly more quirky trademarks that are out there. And just because you've maybe cleared a word doesn't mean that you might not fall the wrong side of a trademark that, you know, for reasons that are completely fair enough, you might not be aware of. Intellectual property is increasingly being used as a form of security, so there are all sorts of issues to do with the way that that's registered, and it needs to be obviously registered as a charge if it is used as collateral, and then that can be registered if it is a registered right on the relevant registry. So for example, for trademarks in the UK, that's the UK Intellectual Property Office, and in Europe, it's the EU Intellectual Property Office. In terms of the infringement side of things, I think it's really helpful, as I said, to think about what's going through the mind of someone who's objecting to intellectual property rights. And the sorts of things that they'll be worried about are losing their identity. So that can be both in terms of the trademark side of things, so customers not being able to find them or being confused and thinking that a different company, a competitor company, is in fact them, through to the sort of the less tangible but erosion of brand identity, which can be really concerning, particularly for businesses that have spent a lot of time and investment in developing a very distinctive brand identity and educating the public as to what a particular product or appearance of a product means. So as I say, this could lead to it being harder to get new customers, the potential for losing credibility in the marketplace. And also there's this issue where there's an innovation angle in particular of competitors leapfrogging to market, so they don't have to spend the time and money investing in the development of a new design or a new invention. And if intellectual property rights didn't exist, it would really undermine any desire to invest in developing new ideas and new forms of creativity. So the sort of the classic example of this is in pharmaceuticals, where it can take over a decade to develop a new drug in some instances, particularly because of all the regulatory process that they need to go through in order to test it, most obviously for safety. So if you didn't have patents, then you would be in a situation where one company invests millions, in some cases potentially $1 billion, on developing a new pharmaceutical, and then a second company could just come along and copy it. That, in very broad terms, is the rationale behind intellectual property rights in general. It's to protect investment in creativity and to give businesses or individuals the opportunity to profit from their creative endeavours. So obviously, in addition to the sort of the business frustration and the loss of custom, there's also the aspect of it being an asset that could be lost. So particularly with a trademark, if its distinctiveness is lost within the marketplace, the value will go down. And obviously, if there's a registered security, then there's also an issue as far as that's concerned. So that is a very high-level overview of why intellectual property matters. If you want to get a bit more information, you can obviously read my book. Now, I'm going to start off with the much more practical side of what to worry about if you have an allegation of intellectual property infringement. And this might sound like it's quite an obvious point, but it's an issue that affects a lot of clients. And it tends to be particularly a problem where there's maybe an overseas office, or it's not terribly clear from the internet who is the right person to contact. So people can often send letters to maybe a wrong address or to an email address that is maybe out of date or not commonly used. And the danger of this is that if it doesn't come to your attention, in some countries, this can be sufficient to say that the claim has been addressed to the right person and you can get a default judgment. It's nearly always possible to set aside this default judgment, but that just creates a hassle, and particularly if it's one where you might not think that there's a great deal to be gained from objecting to it, to fighting the judgment, then you've lost the opportunity to negotiate a settlement and you're left with having to pay fixed costs and then potentially the fixed damages fee, depending on which right it is. So number one bit of advice, make it super clear what address should be used for any correspondence. It's common for people to set up a legal @ and then your domain email address, so that that's a really obvious place for people to direct correspondence. And similarly, an appropriate address, postal address, is always sensible. Believe it or not, some people still do use faxes. So if you do have a fax number, then make sure that is properly manned. I believe it's now possible to get it always sent digitally, even so you don't have the old-fashioned concerns about paper running out. but nevertheless, you need to make sure that any email address that the fax is sent to is manned and that that will be dealt with. Next up, well, eagle-eyed viewers will notice that I have recently been to Harry Potter World. So yes, the sort of, I suppose the message from this is that you need to think about protecting yourself both in advance and potentially after an issue has arisen. So I would say the vast majority of businesses that I encounter do have some form of legal insurance, but there is nearly always a carve-out for intellectual property infringement. And that's because IP is one of the more complex areas of law and quite a challenge to predict how it will, the exact way in which an issue will arise and how it should be dealt with. So in instances like patent infringement, the liability can be very large, both in terms of the damages and the legal costs that can be incurred. So it does make sense for insurers to be reticent about covering this, but it is possible to get specialist intellectual property insurance. And I think this is something that more and more businesses are considering, particularly when it's an area where the risk, for example, of patent trolls is quite common, or where there may be a brand and actually they want to get the insurance to protect themselves against counterfeits, which is a common issue. So it's always something to look into and to think about more carefully. And if you want to find out more, do get in touch. Even if you don't get insurance in advance, it is possible to get what's known as ATE insurance, and that stands for after the event. So the IP infringing event has occurred and it's after that moment in time, but you still want to look at whether it's possible to get insurance. Generally, this is not available if you're a defendant, but in some instances you may find that you're threatened with infringement, but actually you have a counterclaim which may be as significant or potentially more significant than the original claim. So it's still worth looking into the possibility of insurance. Similarly, there is the possibility of litigation funding. This, again, can be harder if you're a defendant, and it depends on whether there is effectively a large monetary remedy that might be available to you in the form of a counterclaim. The starting point when you get any allegation of IP infringement is to work out exactly what is wanted. So this is a question of reading the letter carefully and getting to grips with exactly what they are most upset about, because that's the starting point for deciding what would be an appropriate way of dealing with this issue and hopefully remedying it before any proceedings are issued. So certainly in the UK, most letters before action will include at the back what's known as undertakings. And essentially this is a contract, a draft contract which sets out exactly what the person writing the letter wants from you. So typically this will say that you'll cease using the particular IP right that's an issue. And then if it's, for example, a trademark, that you'll stop using that word or logo or anything that is confusingly similar. And similarly, if it's a design, it would be that particular design or anything which has the same overall impression. And these are the legal tests for infringement as far as trademarks and designs are concerned. The test for copyright is whether it is identical or copies a substantial part of the original. So typically what's asked for is that the action that is ceased corresponds to the scope of the intellectual property rights. Sometimes people try to go a bit broader, and this is something to watch out for if it's included in any undertakings. In addition to stopping the activity, there's often a request for what's known as delivery up or destruction of any infringing items. So this is obviously more of an issue where you've got a physical item. So this could be, I do a lot of work obviously with the fashion industry, could be t-shirts, dresses, jeans, that sort of thing, that they would either be destroyed in a manner that is hopefully ecologically sound or delivered up. And then there are ways of working with different charities to remove branding or potentially sell them on that basis. This often what's more important for somebody writing a letter is not necessarily that you stop doing it, it's that they're able to trace back through the supply chain to work out exactly where the problem is coming from. I would say this is more of an issue as far as counterfeit goods are concerned, but it can be a problem with all sorts of different industries. So, for example, where there's a patent infringement, in addition to stopping the infringing activity, it's common to want to know who the supplier is so that it's possible to determine whether it's appropriate to take action against them. And what will be going through the mind of the person writing this letter is that there could be a problem in their supply chain, and they'll be wanting to find out if there is, maybe somebody, one of their suppliers or distributors, who isn't selling the stock through the authorised distribution channels. So this can be a good form of leverage in terms of reaching some form of settlement. So you could say the supplier details will be contingent on not paying a monetary remedy or limiting that remedy. Obviously, money will always be a factor, particularly if somebody's had to instruct a law firm to write to you in the first place. But it is fair to say that very often, if the activity is stopped, then that is often the primary concern. And it may not, certainly in the United Kingdom, be worth pursuing somebody for the costs that have been incurred once the activity that is concerning has ceased. So it's a good kind of pressure point and something to think about, particularly if you've had to incur expert intellectual property costs in order to deal with the issue. You might not want to pay the other side's legal costs, so the person who's written you the letter. And obviously it does depend a bit on how serious the infringement is. So if what has been copied or is almost identical, so say a photograph that has been taken without permission, that's at the slightly more serious end as far as it being an obvious infringement, compared to, say, a trademark where it's a bit more borderline. So your trademark is similar, but it's not guaranteed that the person writing the letter would succeed if they brought the proceedings in court. Another thing that's commonly asked for is a public apology. And essentially the rationale behind this is that it's re-educating the public who've been misled by the intellectual property infringements. This may be appropriate in some circumstances, and it's certainly a remedy that can be available but isn't commonly available. It's worth looking at the wording that they propose, but by and large, it's not something that's advisable to enter into. Finally, there's the agreement to not use the brand name or product design in the future. So obviously, in addition to ceasing doing something, that would need to cover the future, that you wouldn't start or issue a new product that may have that included. There is it's relatively common to, in addition to the letter that encloses the undertakings, for there to be sent what's known as a without prejudice letter. So this may, in slightly more opaque terms, outline the terms of a settlement and what would be acceptable. So this can be very helpful because it helps to narrow down the points in dispute and highlight to you whether their primary concern is ceasing the activity or whether it's really something that is so serious and damaging, and where potentially the past damages are so substantial that it's not going to be remedied without a monetary payment or a court battle. So this brings us on to understanding the allegation. And because of the nature of intellectual property rights being so broad, it's actually quite difficult to go into this in a lot of detail in the 30 minutes that we have. But there is a very wide range between copyright in a photograph, which may have been taken from the internet and used on either social media or a website, through to patent infringement based on the use of particular software features. And in terms of the amount of cost and the amount of damages, those are really the two extremes. The copyright isn't always completely straightforward, I think it's fair to say. So software can be obviously changed and still infringe if it's the source code that's been copied. And the way that copyright works is that it's the substantial parts of the original that is infringing. So you don't necessarily have to have something that looks terribly similar to the original if what was taken from the starting point, so that could be a photograph or a drawing or source code or music, if what is taken is a substantial part, for example, a key melody in a song, then that could still be an infringement. Design rights are, as it should be clear from my last webinar, quite a complicated area of law. There are essentially 4 different design rights that cover the UK. And, if you add copyright into the mix, which can overlap with designs, you've got 5 different rights. Very broadly speaking, designs protect visual appearance of the whole or part of a product. They last for between 3 years for a EU unregistered design, up to 25 years if you register the design. And really you need to register it as soon as possible, ideally before you have published the design. But if not, it is possible to register within 1 year in the European Union, at least. If you've already published, then there may be issues getting that registration in other territories, such as China. The design, the test again varies dependent on whether it's an EU unregistered or registered design, or if it's a UK unregistered design. The UK unregistered design right is slightly more narrow than the European counterpart. It really only affects the shape or configuration of the whole or part of a product. So it tends to be used more in the context of industrial designs, although I have used it quite successfully in the context of fashion. So just because it appears to be much more industrial focused doesn't mean that it doesn't have use when you're looking at more tangible creative products. The tests, so for EU and registered designs, what you're looking at is whether there is the design that copied has the same overall impression. And it might sound like quite an easy statement that rolls off the tongue, but it's actually a lot more complicated than that, particularly when you're looking at unregistered designs, because what exactly is the design takes quite a lot of thought to formulate. So quite often what I find in practice is that because designs aren't terribly well understood, even within the legal profession, the way in which the infringement is formulated isn't always quite right, and there can be scope for immediately batting away a claim for design right infringement simply because it hasn't been properly formulated. With trademark infringement, again, the question will be which mark, but because trademarks are registered rights, it tends to be much clearer which right is being talked about and how it infringes. There is a sort of what's often termed an unregistered trademark, which is essentially a cause of action known as passing off, which is available in the UK. The sort of civil law counterpart is known as unfair competition. And essentially this means that if a indicia of origin, so a sign of some description, is copied, then there may, provided that you can show that consumers associate that indicia with the source of the business, it is possible in some circumstances to rely on things like a word, a brand name that isn't registered, or in some cases, if it is registered, that can also be okay. Or even the get-up, so the appearance of a particular product. Passing off is a harder cause of action than trademark infringement, but it is something which is commonly raised, and it's really worth getting to grips with the allegation in order to understand whether it has merit in the particular letter that's been sent to you. Finally, patent infringement is obviously a very specialist area, and it really depends on what the patent covers and whether the patent has been used successfully against third parties, so anybody else who's been sued on the basis of a patent, as to the rationale as to whether you want to take action. And I'll come on to that in a bit more detail in the next slide. The bottom line is that some intellectual property claims are much simpler than others, and unless it's a right that you feel very comfortable with and you really understand exactly what the legal issues are and whether you've got a potential defence or not, it really is worth speaking to an intellectual property lawyer. As I said at the bottom in bold, it's really worth investigating the issue, because at first glance you might think this is completely unjustified, but in some circumstances it can be a particular employee maybe just took a bit too much inspiration from the internet, and there could be some merit even if it's obviously not something that your company would have intended to become an issue. So investigate the issue and find out exactly what went on. And now we come into the Chamber of Secrets, pardon the pun. So the things to consider in response, and this is really the most important slide. Do they own the rights? As should be clear from my last webinar, this is a really common problem in lots of businesses, particularly where they use a lot of third-party contractors and maybe don't have appropriate contracts in place to transfer any IP rights that are created. Unless something is created by an employee, and again this only applies under English law, the first owner of the intellectual property rights is nearly always the creator of those rights. So, for example, if you have your logo designed by somebody on the internet and you haven't got an appropriate contract to assign the copyright in that logo, you might find that you have a registered trademark which you registered for that logo, but you don't actually own the copyright in the logo, and you could potentially have a claim from somebody in the future. There are lots of defences to that claim, but it's really worth getting the right situation sorted out. So that's thinking about it from your perspective. But when you get a letter in and somebody is alleging infringement, one of the first things that you'll want to do is to ask them to prove that they own the rights. So this could be in the form of a witness statement, it could be in the form of the relevant contract, it could be in the form of showing the details from the register if it's a registered right, and particularly when the person alleging infringement is a licensee, it's very common for people to forget to register a license on the relevant register. So this is, an important point to raise quite early on. In terms of the strength of the rights, as I mentioned before, patents or any right where it's been challenged in court successfully, you're going to have evidence of that being a much stronger right than something where it's maybe a bit more nebulous, like an unregistered design, where they'll need to prove all sorts of things, in particular that it was published within the relevant period. So if it's an EU unregistered design, you only have 3 years from the date of first publication in which to rely on it. And if it's a substantially longer period than that, then obviously those rights have expired, and consequently the rights are very weak. In fact, they're non-existent. So there are all sorts of processes that you need to go through when you get the letter to determine A, whether the rights exist at all, and B, if so, the strength of them. Bear in mind that just because somebody was successful in relation to an earlier patent or trademark case, it doesn't mean that they'll be successful against you, because the way in which the infringement would be formulated is going to be different in every circumstance, unless, I don't know, for example, it's exactly the same issue. I don't know, it's a sale of a counterfeit good without your knowledge, then, and there have been previous successful disputes against the same supplier, then I think it's pretty much bang to rights and they've got a very strong case. So then you need to focus really on settlements. As far as infringement is concerned, where there are unregistered rights, a very common defence is that there wasn't copying that occurred. So, for example, for there to be copyright infringement, you need to show that there has been copying of the copyright work. And this can be quite a challenge for a rights holder. I would say there's a bit of a sliding scale here. So, for example, if what's copied is near identical or identical, then proving that there has been copying is obviously very straightforward, because there's a very strong inference that it has been copied. At the other end of the scale, if it's more close to inspiration, then proving that the copying has occurred can be a lot harder for the person who wrote the letter. Again, this really comes into the investigation angle that I mentioned in the last slide. It's really important to look into whether this is a supply chain or a design issue, or whether it's simply a coincidence. So it could be that you both were inspired by the same source material. I'm thinking of it more in terms of the fashion industry, for example. But there are these sort of trend forecasting agencies like WGSN, and they look at the trends that are going on. And it's very common for people in the industry to look at exactly the same source material and maybe create what looks like a very similar product or a similar pattern, but this can, in some circumstances, simply be a coincidence. So it is worth getting to grips and understanding exactly what happened internally before you write a response. And it's always possible to ask for more time if that process takes a little bit longer than you might anticipate. The next point to consider is whether or not there is a counterclaim. And this could be, for instance, if there has been an allegation of trademark infringement, particularly if it was made to a supplier or to one of your customers, so a wholesaler or a retailer. You may be able to say that what has happened is a groundless threat of trademark infringement. And in those circumstances, if there has been a significant loss, for example, if you lost a contract as a result of the allegations, this can be quite a meaty claim to make in response. Having said that, there are very few successful groundless threats cases in the United Kingdom, and it's not as commonly used as it used to be, but it's still something to bear in mind and to be careful about. Another obvious form of counterclaim where there's a registered right is to apply to invalidate it. And strategically, it can be a good idea to issue proceedings to or start the invalidation process at the office of origin, particularly if they haven't issued proceedings yet. So this is in the context of European rights, at least, known as an Alicante torpedo. And basically what it means is that you start proceedings to invalidate the trademark at the EU Intellectual Property Office. And once that has begun, it's not possible for them to rely on that right whether it's a design or a trademark in the United Kingdom, it can be a very good strategy, and consequently what is commonly the case is that people will actually issue a claim form before they write to you, and so that is there and they preserve their position. Once you have issued a claim form in the United Kingdom, or in England anyway, you have 4 months in which to file and serve a claim. So they have started a clock ticking by issuing the claim, but it does normally 3 months is enough time to reach a negotiated settlement. The other question that can often arise where there's a contractual issue is whether there's a claim against someone else. So this could be, for example, if you're a shop and you've been accused of intellectual property infringement based on somebody else's product that you're selling in the shop, you may well find that if you check your contract, you've got an IP warranty in your favour from the supplier of those goods. So, for example, there was a famous case a few years ago where Topshop sold various T-shirts that included a photograph of Rihanna. So Topshop was sued by Rihanna herself in relation to the unauthorised use of her image, but then Topshop was able to claim under its IP warranty against the supplier. So it's really worth looking at any contracts that you have in order to see if there is another way of either getting the claim funded or passing the liability on to somebody else once you've dealt with the claim. It's quite common where there is an IP warranty for people to have the person who gave that warranty to have the opportunity to take on the claim and effectively take responsibility for the strategy and for paying the legal fees. So have a look and see exactly how that works, and again take legal advice as to what is the optimum strategy for you. So again, we're back in Harry Potter land with a delightful photograph of Weasley's puking pastels. And as the point really here is that there are lots of different ways of responding to a claim, but some are slightly more appetising than others. What some businesses choose to do is to simply ignore the issue. This is different to obviously not being aware of the issue in the first place because you haven't got your postal systems up and running or the system for getting notified of a claim completely watertight. The problem with ignoring an issue is that it generally doesn't go away, and you will find that somebody will take action. This could be in the form of issuing proceedings against you, or it could be, if it's online, it could be filing notices and takedowns against all product listings, which obviously creates quite a disruption as far as your online stores are concerned, if that's your business. Another option is to stop selling or stop infringing in whatever way has been alleged, but to otherwise ignore the letter. This is quite a common approach that I find, and dependent on the seriousness of the issue and the extent to which the infringement has been going on or how problematic it is. Or again, you can sometimes tell whether this is a one-off concern of a client or if it's something that's been happening on a wider scale. In some instances, this can resolve the issue once and for all. They've still got the kind of the threat of this, and because the limitation period, so the time period in which it's possible to bring a claim in the United Kingdom is 6 years, this means that you've potentially got a liability hanging over you for 6 years. If the size of the damages is not terribly significant, then this may not be something to worry about. But nevertheless, it is, as a lawyer, I do like to get things properly resolved. And if you have this potential liability hanging over you, it is something that you always need to be aware of at the back of your mind and maybe make a contingency for in any accounts. Another common tactic is to provide undertakings, but not in the form that have been requested, but rather in a form that is acceptable. It's quite common to provide these signed, so effectively you're presenting a solution as a fait accompli and leaving it up to the person who wrote the letter to decide whether or not that's the way in which they want to deal with it. If you agree not to infringe and you maybe include a time period in which you will sell off existing products, that might be something that people are willing to accept even if they don't get payment. Again, as always, it depends on the seriousness of the issue, but it can be where the level of infringement is fairly low level, quite a good strategy. Other than that, the remaining options all involve having a conversation, so in order to reach hopefully a negotiated settlement. So the sorts of compromises that are commonly acceptable are things like modifying a product. So if it's a design issue, there may be a particular feature that you can change, or altering a brand name, or potentially using the trademark that you've been using or the name that you've been using together with your house brand so that there is no confusion. As I say, ideally you'd want to allow for a sell-through period, and what's reasonable tends to depend a bit on the industry and the way in which the sales work for that particular industry. If there is a potential counterclaim, then obviously that is a much more aggressive way of responding, either by issuing a counterclaim, particularly where there are registered rights, or engaging in a separate cause of action. So you might see that maybe one of their trademarks is vulnerable. It might not be one that they've alleged against you, but if you wanted to take a much more aggressive stance, you could review their portfolio and pick off rights that are much more vulnerable and use that as leverage to reach a settlement. And then finally, as I said earlier, the warranties and indemnities in any contractual arrangements are really worth looking at in quite a bit of detail to see if there's a way of effectively passing the responsibility on to someone else. So, final summary, the top tips. I think 5 is, it's always a bit of a challenge to just limit yourself to 5 tips, but essentially it's make sure that you're set up to be quickly notified of any allegations. So that's obviously making sure that there are clear addresses, email addresses, and potentially even telephone numbers for notification. Checking your insurance policy to see if it's possible to get insurance, to claim under an existing policy or to take out a new policy as an after the event insurance policy. Identify exactly what the objective is of the person who has written you this letter, and understand whether the claim has a strong legal basis or not, because that will determine the strategy that you decide on with your lawyer. So you can find out more either by contacting me, that is my email address. Obviously, my website and more importantly, the book itself goes into all of this in quite a lot more detail. I keep an active Twitter following. I engage in all sorts of different issues, but feel free to contact me on there. And there is also a dedicated Twitter for my book, which is predictably at Euro Fashion Law. So please feel free to get in touch with me via one of those various channels. And finally, a bit of information about Gunner Cook itself. This is our office addresses in London and Manchester. And I really hope you found that useful.